Okay, I think we are ready to begin. Looks like the attendees are popping in now.
Great. Just let me know when you want me to
Okay.
start my part.
Okay, Carrie, we are ready to start.
Okay, welcome everybody to our combined AACO and NAA-TAA call. This is Carrie Landers with AACO. You will be hearing for both Carries today. So we are so glad that you were able to join us for all of this information, and thank you very much to NAA for helping facilitate this. We definitely appreciate that. I am going to turn this over to Jen, and she's going to go over some details on how this is all going to work.
Great, thanks, Carrie. We are so happy that you were able to join us today. We are offering this call today as a webinar, which means, unfortunately, all of our attendees don't have the ability to speak, but you do have the ability to ask us questions and to chat with our panelists throughout the call. You will see at the bottom of your screen a sort of a dashboard, a pop-up. If you click on the Q&A there, that's where you can go ahead and ask your questions throughout the call. Our presenters will take questions at the end, and I'll be able to assist in reading those questions and getting those answered. You can also use the chat feature as well if you wanted to comment there, either with our panelists or other attendees. With that, I'll turn it back over to you, Carrie.
That'd be Carrie Cooper.
Yeah, hi, this is Carrie Cooper. I'm with the Tulsa Apartment Association, and I'm going to introduce our speakers for today. So Greg Brown, he's the Senior Vice President of Government Affairs for the National Apartment Association. Greg joined NAA in 2010 to grow and expand the advocacy program for NAA and increase the impact of the apartment industry's voice on public policy matters. So Greg leads an amazing team of advocacy professionals focused on federal policymaking, supporting the advocacy efforts of NAA's state and local affiliates, and effectively deploying political capital through the NAA PAC and grassroots program. Greg has been a housing advocate for 20 years, representing private sector, single family, multifamily, and commercial owners and operators and developers, as well as local public agencies and not-for-profit organizations. And Greg is also a proud graduate of Texas A&M University and the American University in Washington, D.C. And our other speaker today is Alex Rosello. And Alex Rosello is the manager of public policy for the National Apartment Association. Alex joined NAA in August of 2018 and works to support both the state and local advocacy efforts of NAA's affiliate network and the organization's federal lobbying efforts. Alex manages an issue portfolio that includes rent control, eviction, and landlord-tenant issues, among others. Before NAA, Alex worked for a small lobbying firm in DC that focused on defense and armed services issues. He's also interned twice on Capitol Hill in the offices of Senator Mark Warner and former Representative Barbara Comstock of Virginia. Alex graduated from Franklin and Marshall College in 2015 with a degree in government. So I will now turn it over to Greg and Alex.
Thank you very much, Carrie. This is Greg Brown speaking. Welcome to you all, and thank you for having Alex and I here today to talk about what's happening in the federal sphere around COVID-19. Our mission today is to tell you a little bit about what Congress has done so far regarding COVID-19 legislation, obviously as it relates specifically to the apartment industry. We're also going to talk about what we've learned so far about the impacts of that legislation, what are some of the issues out of that legislation, and then what's coming next, what our next set of asks will be, what the outlook is for that legislation, et cetera. So as was reported earlier, we're going to try to have time for questions at the end. Use the chat function. I'm happy to answer whatever we can. And if we are not able to cover all the questions today, we'll certainly follow up with anybody who has questions after the presentation. So I have to give a brief disclaimer that what Alex and I are giving you here today is not legal advice of any kind. This is strictly informational purposes only. What we hope will be helpful to you to understand what the laws say, what the Congress has been doing, and just expand your knowledge in that area to hopefully help you in your day-to-day and help us advocate for a better outcome from the legislation that Congress is working on. So let's start with a basic overview. There have been 3 bills that Congress has passed since COVID-19 really took hold of the country. And when I say that, I'm talking about middle of March. Right after the Advocate Conference was when you started seeing a lot of the shutdowns and shelter-in-place orders, et cetera. So we've got 3 bills that have been passed, a 4th one that we're expecting to, well, actually now a 5th one expecting to take shape here in the coming weeks. So we're going to go through the first 2 of these bills very quickly, and then focus a little bit more on the 3rd bill because that's the most significant one as it relates to the apartment industry. So phase 1 was the Coronavirus Preparedness and Response Supplemental Appropriations Act, which is a very long way of saying the first tranche of money that was sent out to help respond to the COVID-19 emergency. So that bill had $8.3 billion, which almost seems like a quaint amount of, it's almost real money, considering what they have been passing more recently. About 80% of that was for domestic concerns and 20% was for the international activities. And most of this domestic money was for research. The CDC, the FDA programs, and then also some money just to expand the capacity of the SBA, the Small Business Administration, to administer its own loan programs. And as we'll talk about later, that they certainly needed every dollar of that to help administer those. We have a deep dive article on this first bill on our website. You can see the link below. You can find this and a lot more resources we're going to talk about today on the COVID-19 section of naahq.org. So please avail yourselves of that. Phase 2 is the Family's First Coronavirus Response Act. This got in a lot more granular detail about trying to help workers and those that would be directly or indirectly impacted by COVID-19. And more specifically, it got into providing paid sick leave or expanded family medical leave for those who couldn't presently access that. So these paid leave and expanded family medical leave provisions are in place through the end of the year. It only applies to employers with fewer than 500 employees, and then there are some exemptions for employers with 50 or fewer employees. That's only in certain cases. So for employees that have a specific qualified COVID-19 rationale or reason, they're all eligible for 2 weeks paid sick leave, and those who have been employed for 30 days or more are also eligible for 10 weeks of family medical leave. And that's to care for either a sick child or if your child is no longer had childcare, the school was closed, which is pretty much everybody now. Now, to help offset the cost of this to employers, there were refundable tax credits that are available to employers to cover the cost of that leave, which is the good news. They tried to work as hard as they can to make sure that money would be available as quickly as possible so that employers wouldn't be sitting there carrying that amount of money for a very long time. There were 6 qualifying reasons for paid sick time that you can see here. The calculation of how much pay for each of these various reasons, it varies by each one of these, so I won't go through them all in detail. But I will say that we had a webinar on this topic, Coronavirus Outbreak, What Employers Should Know, which covered all of the paid leave provisions of that phase 2 bill. So I would recommend, if you have not watched or listened to that video yet, it was conducted by 2 attorneys, outside attorneys that NAA works with. A lot of great information in this webinar. I would encourage you to watch it. It's straight up 1 hour. And a worthwhile hour of your time, and you can find it at the website shown at the bottom of this slide. So phase 3 is the most impactful piece of legislation passed yet. This is the Coronavirus Relief and Economic Security Act, or the CARES Act, it is commonly called. It included several major provisions: assistance to individuals, to businesses, furniture restrictions and consumer reporting that is relevant for us, mortgage forbearance to qualified properties, a broad-based eviction moratorium, and then some expanded federal appropriations for housing specifically. And we have a deep dive article that can be found at the link the bottom of this slide. You all will get all these slides, is my understanding, after this presentation. So if you can't write that fast, you can either wait for the deck where you can see it, or just go to the COVID-19 section of NAA's website and you can find it there. So we'll start with the assistance for individuals. You've probably all heard about this. The unemployment assistance programs were all plussed up significantly. Now you get an additional $600 per week for 13 weeks on top of whatever state unemployment insurance support that you get. That's all coming from the federal government. Not all states have deployed that yet. Many states have, but some have not. So you're kind of on a rolling basis here of getting these dollars out. In addition to that, we have the recovery rebates, which are the checks that are being sent either on paper or electronically to individuals and families, depending on your income. You get $1,200 per individual, $2,400 per couple, plus $500 per child. Again, there are income limits on this, and it phases out the higher that your income goes. This individual assistance is not directly related to us, but it's indirectly related to us in the sense that the thought among members of Congress was that this kind of money would be used to pay all bills, including rent. Whether or not that's actually going to happen is what we're probably all going to see here this week and next as the May 1st collections begin. There's also assistance for business, 5-year net carryback of net operating losses. This means that if you are operating at a loss this year, or in this case, if you had losses last year or the year before, you can carry those losses backwards in time to recapture taxes you previously paid. It's a way of generating cash flow in the short term. This was used after the 2008 recession and financial collapse quite extensively, and a lot of firms were able to generate a lot of dollars by reclaiming those previous taxes. There is a employment retention tax credit, basically the federal government paying you to keep your employees on the payroll. They cover 50% of wages with certain limitations. So that's another one that can be helpful to those trying to keep some folks paid. The SBA loan programs were also expanded. And again, we have a deep dive article on this at the link that you see below. Finally, there's this, finally from my section before I turn it to Alex, there's a consumer reporting restrictions for furnishers. So what this means is if you agree to a payment plan with a renter, you cannot adversely report that renter's obligation or their account. It has to be reported as current. Or you have to report as their status prior to the accommodation. It also applies to the acceptance of partial payments. Now this protection ends the later of 120 days after the enactment of the law, which would be, that date was March 27th, or 120 days after the date of the national emergency declaration by the president. So this is significant, obviously, because those that are engaging in payment plans or partial payments will not be dinged on their consumer credit reports. I'm going to turn now to Alex, who will take on the next several sections of the CARES Act. Alex.
Thanks, Greg. So the CARES Act does offer or give an avenue for taking mortgage forbearance for owners of multifamily properties. This is limited to properties that have federally backed mortgages that have experienced a COVID-19 related hardship. So if you lost rent during this time period or haven't been able to collect all of it, you could be able to receive some forbearance. The forbearance is for up to 90 days. It's also in 30-day increments. So you have to request before the end of the first 30-day increment if you want another 30 days and subsequently another 30 days. Now it does come with strings. So you would be prohibited from filing for eviction for non-payment, also issuing a notice to vacate or applying late fees for non-payment of rent. This is not restricted to COVID-19 related financial hardships. So this is for all your residents, whether they have a financial hardship or not. And you would only be allowed to issue a notice to vacate after the forbearance period is over, and that would be a 30-day notice. So the resident would have 30 days to respond to that. You can go to the next one, Greg.
Trying, Alex, just 1 second. It's not
No, it's okay.
it's not responding to me. Okay. Don't know what's happening. There we go. Sorry.
Oh, there we go. Okay, so here are some of the challenges we have with the forbearance sections. Obviously not perfect. The timeline with the eviction moratorium is out of alignment. So the eviction moratorium is for 120 days, so I'll get into the next section. This is only for up to 90. There is a lack of clarity from Federal Housing Finance Agency. There are different rules for Fannie and Freddie. So Fannie Mae, they make borrowers pay in installments over 12 months beginning after the forbearance period is over, while Freddie Mac is kind of more flexible with that. So it might be hard for some housing providers to repay that amount over 12 months. We would like that to be housing providers to be able to pay that on the back end of the loan. So that's something we're going to try to accomplish in phase 4, which Greg will get into later. There's a suspension of evictions due to non-payment could extend beyond the 90 days. So that refers to the notice to vacate requirement. And most importantly, it could result in a black mark and affect future deals. So we've had members who have come to us with concerns. They've said their lender has said, this could affect, in the future, being able to get future financing, and that's a big deal. So another thing that needs to be addressed. Next one, Greg. So the eviction moratorium, a lot of confusion about this, so let's go over the basics real quick. It applies to covered properties, which I'll get to in a second, so it's not the whole universe of rental housing. And it's for 120 days from the date of enactment. So that was March 27th or 6th, it's now April 27th, so it's been about a month. You're prohibited from filing for eviction, for non-payment, assessing any type of fees or penalties on that rent that's essentially deferred. It's not restricted to COVID-19 financial hardship again. It's not limited in that way. And this, at first we thought that this was just an oversight because maybe, it was moving very fast. It still came together in like a week. But since then we've learned that that's not the case. We've had conversations with offices on the Hill. They've told us they didn't want to put renters and housing providers in the position of determining who gets, this protection and who doesn't. Obviously, we would like that to be more limited, and again, that's something that we hope to address in phase 4. This is separate from the forbearance, so this restriction is occurring right now. The forbearance section only applies when you take the forbearance. So you could go 60 days into this, decide you want forbearance, and you could take it for 90 days. You could end up going beyond the 120 days with these types of restrictions on you. It's very important that you work with council to understand how the CARES Act intersects with all the myriad of patchwork of eviction mandates that are across the country. I know that Oklahoma doesn't have like a statewide provision that's come from the governor or from the legislature, but there are court closures that could be in your area that would prevent you from accessing the legal process at this time. So it's important to understand that. So these are covered properties. These is all in the act. It states that every program under that's named in the Violence Against Women Act. So it's all of these properties, all of these programs. So housing choice vouchers, project-based rental assistance, Section 202, NA11, HOPWA, et cetera. These are all there. Additionally, it's everyone with a federally backed mortgage. So that's defined as if it's yours is from a GSE, i.e. Fannie Mae and Freddie Mac. If you have an FHA/HUD assisted mortgage, VA, or USDA. You can go next. Okay, so the key takeaways remember this applies in case of non-payment of rent at covered properties. So for example, if you had a Section 8 tenant, this eviction moratorium would only apply for, and you only have one, would only apply for them. At least that is our interpretation. You're prohibited from filing evictions or collecting late fees during the moratorium period for non-payment of rent. When the moratorium ends, if the residence is not current, the late fee provisions under the lease would apply. So residents are still obligated for all the rent during this period. It doesn't cancel it. I've been thinking about it. It defers it until the end of the period. It does mandate a temporary hold in certain eviction proceedings. So again, it doesn't mean rent's forgiven and unpaid amounts will accrue. So National Low Income Housing Coalition they've compiled a list of, they don't say it's exhaustive, but a list of covered properties. So I would encourage you, if you're not sure, to go check that out and then contact your servicer. See if you can get some confirmation of whether or not you have a covered property. There's a lot of ambiguity in the definitions that are being exploited. So even under covered properties, even though Congress has said its intent aligns with the interpretation that I'm giving you, you really need to be cautious about how you move forward. For example, it's probably okay to notify residents in the form of a letter that, explaining what's going on, stating that they're still obligated to pay rent. If you're in a covered property, they're still obligated to pay rent, and direct them if they need help or assistance to programs that they can access in your state or in Oklahoma or in your area. So it's important to work with counsel to understand the intersections of these things. There's also some ambiguity about the notice provision, so that they were really general in how they chose the notice to vacate term. That term can mean a lot of different things, and we've gotten a lot of input from eviction attorneys that there's conflict in how this is being interpreted and applied in court. So for example, it could mean that notice to vacate being, is it a pay or quit notice, or does it apply to other types of eviction notices? It's not especially clear. So do be careful. Next. SBA. So this is probably something you've heard a lot about. They had to reauthorize funding for this program because it had run out relatively quickly. So it was an initial $349 billion for Paycheck Protection Program, which were forgivable loans. Businesses with 500 or fewer employees or who met the SBA employee revenue size standard are eligible. Excuse me. The loan size is determined by your payroll costs multiplied by 2.5. And the amount of the loan, 75% of it must go to cover your payroll costs, and 25% of it can be used on routine rent, mortgage, and utility obligations. Maintaining employee compensation levels will impact loan forgiveness. We do have a webinar on this. We had a law firm, Womble Bond Dixon, help us out because it does get very complicated. So if you need more information on that, I probably didn't do it justice at all. Please check that out. It's very comprehensive. So the challenges. This first challenge was because of the regulations that were promulgated from the Small Business Administration. So if you're a passive owner, if you're an owner with a third-party management contract, if your business with under 500 employees, you're ineligible for this. It's a big problem, and we're working on advocating for this removal, passive business exclusion, and being able to include multifamily firms within the category of businesses with less than 500 employees across multiple locations. So this is an exclusion that food service industries have. They have multiple locations and hotel industry. And we feel we have a good argument that we should be included in that exception.
Yeah, thank you, Alex. So in addition to the provisions that Alex just reviewed, there was also a significant amount of money appropriated through HUD in the CARES Act. You can see all the various amounts there. Two things to point out to you. The CDBG money, the $5 billion, that is distributed by formula. As you all probably know, there's a formula to the Community Development Block Grant. So every locality that's eligible gets money according to their formula. The dollars that are being allocated through this $5 billion are eligible for paying for rent. But you have to, the locality or the recipient of the dollars has to make that decision actively in order to use it for those. So what we are encouraging our members to do is to reach out to their local governments who have CDBG money and say, have you received your CDBG money? And are you going to use it for helping people pay rent? This is in lieu of the rental assistance program we did not get in the CARES Act that we specifically asked for. So it's a very small amount of money relative to the need, but if your locality or your state gets this money, it's worth asking them to utilize some of it to help people pay rent, which ultimately benefits the industry because, for obvious reasons, keep the owner-operators whole in this process. The other significant piece I'd point out is the Fair Housing Enforcement Grants. There was $2.5 million allocated toward this activity. I can't say that any of us feel that was necessary, but it was done regardless, so we're waiting to see what the implications of that are in terms of enforcement activities on owner-operators around fair housing concerns. The other good thing I guess I should mention is that the HUD Secretary does have broad waiver authority here with these dollars and with the programs themselves. As many of you know, we've been seeking greater changes to programs like Section 8 for quite a while now to make it more user-friendly to private operators. And so perhaps there is an indirect benefit to that effort through this waiver authority. We'll have to wait and see about that. So here are the key takeaways for the CARES Act. A lot of resources for business, including housing providers. Have to admit, of course, that we did better on the tax side than we did on the direct funding side. Certainly the SBA program started out in a great place and looked like a great opportunity for our member firms, and then turned out to be a lot less useful for some of the reasons that Alex mentioned, and just the way it was crafted. So now we have to do cleanup in this next legislation to try to get some of that back. And as you saw, it is heavily subscribed, so they ran out of money. They just reallocated another $300 billion towards that. We're hoping that that will last for a while, past the point at which we can get this thing fixed so that some of our members in the industry can access those dollars. The mortgage forbearance is limited. As Alex described, it's really just for federally backed mortgages right now. Now, we would like to see all all borrowers have the ability to access some form of forbearance. And that is one of our asks for the next bill. Alex went into detail about how problematic that eviction moratorium is. We opposed any moratorium on evictions, as you would expect, throughout this process, with the caveat that if they were going to go down that road, then it needed to have significant guardrails around it. Most specifically, meaning it had to be restricted to people who actually had an impact from COVID-19. And the original draft language on the provision did have that. Ironically, the House Democrats' first offer was, it was a longer moratorium, but it had very specific parameters that you had to be affected by COVID-19. And it also very explicitly said you could still evict for other reasons than non-payment of rent. What we got was lack of connection to COVID-19 and a very imprecise drafting of language around the ability to evict those for reasons other than non-payment. So another area of cleanup that we have to go fix. SBA, we've talked about it extensively. And then there was no rental assistance program. Again, the original proposal from House Democrats had a $100 billion rental assistance program. Our understanding is that the staff, there's one of a couple of reasons why we did not get rental assistance. Number one, they couldn't figure out the right channel to send it down to individuals who needed it. And they were in a rush and they didn't have time to try to sort it out. So they just skipped over it. Two, the prevailing opinion was the unemployment insurance boost and the recovery rebates I covered earlier those would take care of it. People would have enough money to pay their bills. And if you look at the amount of money in the unemployment insurance program now, some people are making more being on unemployment than they were working, which is, that's not the outcome Congress wanted, but that's what it got. So yes, in theory, those dollars are there for many folks to make their rent payments. The challenge is we don't know if they're actually going to use it for that, especially if they're in a place where you have a moratorium on eviction. So that's something we definitely have to fix in the next package. So let's talk about phase 4. So phase 4, I guess would probably be more called phase 5 or phase 4.5 or whatever. We've had 3 bills passed. We had a 4th bill passed that had SBA loan money included in it. So now we're on to the next phase, whatever you want to call it. And that package has started. Initially was going to be all about infrastructure development because we were looking at, the president and the Congress were looking at ways to get the economy started again. So they'd spend a lot of money on building and infrastructure. We have a whole set of requests on that. So sure, that's fine. But we still need relief from the immediate crisis. And so the debate has shifted back to that. However, we have a difference of opinion on the Hill as to whether or not we should do this at all. And really that's because the Senate Republicans are of the opinion that we need to let the first 4 bills do their work before we start spending money again. And then we have the House Democrats who are very interested in spending more money on several different priorities. So you have sort of a loggerheads there. Now the president has said he is very interested in doing another bill with relief with some caveats. So we'll see how that 3-way negotiation sort of works out as the process moves on. Here are our asks. I've kind of alluded to these already. We need this emergency rental assistance program, and some of the parameters that we need on that is got to be enough money. So something on the order of $100 billion. The dollars need to go to the owner or to the property, not just more cash in the pockets of individuals. They have that now. We need something that will actually keep the properties whole. And we also want the most efficient channel. We don't want a whole bunch of administrative bureaucracy in between getting the money in the hands of the property and the federal government, writing the checks, so to speak. There are a lot of different options under discussion to do that. You could use some version of a voucher program like Section 8. You could create a fund that an owner would apply towards and say, this is how much lost rent I had in the month of May or the month of April, and I need a check for this amount, and they would be paid for that. All different ideas are being discussed, and we're trying to figure out the best route that works for everyone and can get the most support on the Hill. We definitely need to tailor that eviction moratorium a lot more. We've got to take care of the COVID-19 connection. We've got to clarify that very poorly written language on the notice to vacate. As Alex said, the 120-day moratorium is followed by a 30-day notice to vacate. So you really have a 150-day eviction moratorium for those covered properties. Our desire would be to see the 30-day notice to vacate inside the original 120 days. So in other words, you have a 120-day moratorium and you can then start your filing process the day after, not another 30-day delay. You don't need it. Local law already protects residents for those kinds of situations, so there's no reason to add another 30 days onto it. Definitely, as I said before, we'd like to expand the access and the fairness and flexibility in mortgage forbearance. As Alex said, some of the requirements for repayment of your forbeared amount, if that's the right terminology, are 12-month increments following the forbearance period, which for a lot of smaller owners is a significant burden. So you've got to make your original mortgage payment plus a 12th of what you owe from 3 months of forbearance. That could be significant. We'd prefer to see a situation where, as you can do in the single family side, you could add that forbeared amount onto the back end of the mortgage. It extends the mortgage, but at least you're not getting hit with that burden up front. It's at the tail end of that mortgage. That's the kind of flexibility we'd like to see for that program. We think, there's a misconception out in the world, including Washington, D.C., that if you give forbearance, then that's a one-for-one for rent that's not being paid. But we all know that is definitely not the case. According to the data that we have, a mortgage is about 34 cents of every dollar of rent that is paid. So there's a lot of other expenses that have to be covered that are not covered by just giving an operator mortgage forbearance. So we'd like to see some additional assistance for those kinds of obligations, whether that's through the PPP program or some other facility. We'd like to see that. And then certainly we want some support for servicers, loan servicers. If they're not hold and they collapse and the whole system comes down. So we need to make sure that the lending and the servicing community can be kept whole as well. And then, as I said before, we definitely want to expand the SBA Paycheck Protection Program to include all of multifamily. You can go to nahq.org/phase4 to see detail on all of these asks. There's a lot of detail that is still to be determined on these. We're in the midst of a, let's get to advocacy strategy. So right now we're continuing to engage with Congress and the agencies. We have a grassroots alert on the street right now. If you've not already taken action, I encourage you to do that. It's been on the street for about a week and 2 weeks now. We have about 15,000 letters that have been sent to Congress already. We need a lot more if we're going to get this done. So I encourage you to do that. We're trying to raise the profile of these items beyond our core priorities through the work of coalition. So we're in coalition with a lot of other real estate organizations. Those of you that might belong to the home builders or the realtors or IREM or NARPM or some other organization like that, NAMA, we're all part of the same group, pulling oars on the same ship, so to speak, on this effort. Certainly, as I said, the message is Congress has to pass more relief measures for the industry and address those CARES Act concerns. So if you go to that link that you see at the bottom there, it's a bit lengthy, but I'll leave it up there for a minute. And that number should actually be for the 15,000 of you that already took action. You can go to this action center, you put in your address, it tells you exactly who your local members of Congress are and senators, and then it tees up a letter with all of our asks, and you can send that directly to their office. It takes all of 5 minutes to do. That's not the only thing you should do, but that's certainly one easy thing to do. We would love for you to work through Carrie and Carrie to get with your elected officials in the state and make sure they know about these things and urge them to take action because of the impacts it could have not only on residents, but on property owners and the industry more broadly. This is our team at NAA. This is your team at NAA. And we're always at your service. So you can reach any of us either obviously through email or call. All of our phones are forwarded to our shelter-in-place location, wherever that might be. And we're definitely here to help. We are happy to take questions, Carrie and Jen, if there is time for that.
Thanks, Greg and Alex. So I'm looking at the Q&A and we don't have any questions. So this usually happens on these webinars. It takes a minute for those questions to come in. So I would encourage those attendees who are on the call who did have a question or a comment on anything you heard during this presentation, please go ahead and go to your bar at the bottom of the screen where you'll see the Q&A. You can go ahead and click on that and type in your questions. So we'll just give it a minute for some people to add those. I know it's Monday, so we're all moving maybe a little slower than usual. Carrie, did you get any questions in advance from anyone?
This is Carrie Landers. I did not.
Yeah, we did not either. I think one of the biggest things that people have questions around that I hear about are, if they have a Section 8 voucher holder, 2 or 3 on their property, does the moratorium cover their whole property? Which I know that you guys kind of addressed that, but if there's anything else you want to say about that, I'm sure they would appreciate that information.
Yeah, as Alex said, our interpretation of the law and our information we have received from HUD is that the moratorium applies to the units that have the voucher, not the entire property. That said, since it wasn't written in the statute that way, we always tell people to be wary of that and to work with their local counsel on that. The way that the attorneys that we speak to tell us is because it wasn't in the statute, HUD is viewed as one opinion on the topic, though they would be a obviously highly respected opinion on that specific issue. So what we give you is how we interpret it, but you always need to work with local counsel on that. Alex, would you agree?
Yeah, no, I would agree with that. Our interpretation and Congress's interpretation, specifically, Chairman Waters and the House Financial Services Committee was that exact interpretation that was a narrowly tailored section. You know, if you have a Section 8 tenant, it only applies to that unit, or if you have a couple, it applies to those 3, not the entire property. But, you know, there are groups that are pushing the boundaries on this here at the national level and at the local and state level. So it's important that you kind of have your ducks in a row, that you're speaking with local counsel, and because ultimately a judge is going to decide this, not HUD and not Congress.
So I knew it would come. We just needed to wait a minute. We do have a couple of questions, so I'm gonna just go by how they came in. So the first one is, if an eviction happened before all of this, is it still in effect, or do I wait it out until after this is over?
I think it would be, my understanding is it's during the moratorium period. If you had one, if you filed before this happened and you just haven't completed the process, taking the CARES Act in a vacuum, you would still be able to go through with that eviction. Now, you know, at the local or state level, courts being closed, you might not be able to you know, execute on that, you know, take that to the end of the process. But the CARES Act in a vacuum, you still would be able to take an eviction for non-payment, you know, to its conclusion. And during this moratorium period, our interpretation is you can still file for a lease violation or behavioral concern, health and safety, that sort of thing. But again, you know, there are groups pushing the boundaries on this. Greg, do you have a?
No, I think that's right. That's my understanding as well. Why don't we'll get some more information on that, Kim, and we'll follow back up with Jen and get some more information on that.
So the next question is, has NAA prepared a compliant affidavit prior to eviction?
I'm wondering if that means, do we have a affidavit of someone who says they've been materially impacted by COVID-19? Or this might be a question for our lease folks. So I'd also suggest we take that one offline, and we'll get together with the lease team and ask them about that. Because at the moment, since the moratorium applies to non-payment of rent, but it applies to any non-payment of rent. So right now you don't have to show any impact from COVID-19. You just have to say, I can't pay my rent. And that's sufficient according to the law. That's one of the biggest problems with it. So if they were to change that, then you'd be able to ask for some sort of documentation, but we're not there yet.
And same, sort of in the same area, Greg, and again, this might be for our lease team, but same person, Robert, asked, you know, cases filed prior to the CARES Act, how does it affect subsequent rent due?
Right, and I think it's a similar question. If you filed an eviction case prior to the passage of CARES, now you're into the CARES Act moratorium, does that still apply? It's an interesting question, because on the one hand, if they were late before and you're about to start the eviction process, you should be able to continue doing that, as Alex said, but now you're in the moratorium. So do you jump the moratorium to the end? That's going to require a little bit more research. It's a good question. We'll get some more information on that.
Okay, thanks, Greg. We have another question that says, I have students living in the property I manage, and since the colleges have gone virtual, will any of this affect the student loans that they use to make the rent payments?
Wow, that's a great question that I don't know the answer to. I have not heard anyone say that student loans will be impacted by the fact that people are virtual. Or that they'll be reduced because they're no longer paying rent. I just had a lengthy conversation with a student housing operator of about 60,000 student housing units nationwide on Friday. He did not mention this at all. One of the biggest challenges is that the CARES Act did set aside dollars for higher education. And those dollars technically can be used as one of many uses for housing. But what's happening is the universities are using to make themselves whole. So people that were paying rent for the dorms, it's being used to fill that hole, not to take care of private operators off campus, for example, who are no longer getting paid under their leases, and people are walking away from their leases. So But that's a great question about student loans. Have not heard that at all. No implications as far as I know for a student loan because of that.
That was it with questions. We have one more. If you have some Section 8, does that affect the non-Section 8 residents? Do they get to tail on Section 8 residents?
Yeah, if that's similar to the question I think we had before, if I'm reading it right, the answer is our interpretation and what we understand from HUD is that the only protection, the protection is only applied to a Section 8 voucher holder, not to their neighbor who is not a Section 8 voucher holder. So I believe the answer to your question would be no. They don't get to coattail on other Section 8 residents. They are separate and apart and have to be considered separate and apart from those Section 8 residents.
I had a member email me a question. They want to know, how do they advise tenants that they are not covered on property, or do we say anything until a problem occurs? I think they're trying to figure out how to let them know that their property doesn't fall under any of the specials or any of the guidelines that are out there right now.
Yeah, I would, it sounds to me like what's being asked is, do we get ahead of this and say, hey, just in case you're wondering, you may have heard, that there's a moratorium. We are not covered because of X, Y, and Z. That's a business decision. It's totally up to you. As Alex said, the best thing to do is to get a firm answer as to whether or not you are covered. So are you federally backed? Do you have any of those assistance programs on your property, what have you? And then if someone comes to you, you can respond and clarify for them, no, we are not covered because we are not a federally backed mortgage and we do not have any of these assistance programs, or you are not assisted by any of these programs on the property. Whether or not you try to get ahead of that, it's a business decision. I certainly can see the validity of doing that. But I couldn't give you a recommendation one way or another. I'd probably defer to you as to whether it's better to get ahead or to just respond to incoming. I see Robert's question about prepared affidavits. We don't have one of those, Robert, and I suggest, why don't we connect offline, bring in our lease people, and we can get you a better answer.
So I guess we'll give people maybe one more minute if they want to go ahead and type in a question. Otherwise, I don't see any in the chat or the Q&A panel. We'll just give that a few more seconds. So if people did have a last minute question.
Oh, wait, Jen, can I say something?
Yes, please.
I think now I understand Robert's question. He's saying that the court, and maybe, I don't know if this is Oklahoma or this is more broader than that, will require an affidavit of compliance that the owner will have to bring that they're complying with the CARES Act when they're filing an eviction. And do we have one for that purpose? That's what I think you're asking. Sorry, Robert, I'm not this dense. I just didn't completely get your question. Same answer though. Now that I understand your question, we will talk to our lease team and get you an answer. I don't know that they have that, although they're preparing a mountain of new forms and material for participants in the lease program related to this. So let me check with them. We'll get you an answer.
I've written these questions down, so.
Thank you, Alex.
Thank you both. So it looks like that is it for our questions then. So I guess we can just wrap up.
Well, we want to thank you guys for joining us on the call. Especially thank you to Greg and Alex, and of course, Jen, who facilitated putting all of this together for everybody. This is the first time that we've done a joint call with AACO, TAA, and NAA. So it was wonderful to have everybody on here. If you guys have any other questions, definitely email Carrie or Carrie. And we're happy to get those answered for you or send them up to NAA if we don't have those answers. You should have those email addresses if you are members. And I think that's everything from us. Thank you, guys.
Thank you for having us.
Thank you.
Appreciate you.
Have a great
Thank
day.
you.
Bye.
Have a good day,
Bye.
everyone.